years, we've seen an unprecedented flood of illegal immigrants into the countries. Millions have poured in. Some were drawn by the promise of a better life. Some fled various forms of economic and other hardships. Some were hardened criminals and gang members, but all decided to break our laws to come here. Rather than stop this, the previous administration threw open the doors, and doing so, openly flouted our immigration laws. The humanitarian parole statute was brazenly violated. Mandatory removal language in statutes became optional. Public charge requirements were ignored. Sanctuary cities were praised as heroic rather than criminal. And most tragically, actual victims of violence by illegal immigrants were downplayed, ignored, and forgotten. The courts contributed to this crisis as well and often stood passively by our immigration laws being ignored. Now that Trump is in office, he's trying to enforce our immigration laws, carry out his campaign promise to the American people to reverse the flood of illegal immigrants. Suddenly, the courts have decided to step in. Democrats encourage this lawless behavior. The Democratic nominee for vice president called ICE Trump's modern-day Gestapo, practically inviting violence against them. According to the Department of Homeland Security, ICE officers are now facing a 413% increase in assaults. I suppose concerns about threats of political violence only goes one way. I agree with my Democratic colleagues that the rule of law is the cornerstone of our republic, but some of our nation's most important laws are those that protect our borders. Several nominees before us today will have an important role in faithfully executing these laws and the will of the American people expressed in our most recent national elections. Turning to nominees, I'd like to start by introducing Mr. Woodward to the committee. Mr. Woodward received his bachelor's and master's degree with honors for American University and his law degree with honors at Catholic University Columbus School of Law. After clerking for 3 different judges in District of Columbia, he joined Aiken Gump, where he practiced for 10 years. There he handled a variety of complex litigation matters and government investigations and was awarded his pro bono service. His practice during this time involved many of the issues he oversees. Go ahead.
Thank you, Mr. Chairman, and congratulations to the nominees and their families. Given the challenges which this administration is facing in court, record-breaking numbers of challenges, we can certainly understand why he wants a team on his side in the administration. Earlier this year, I asked Justice Department nominees a simple question: may a public official defy a court order? Shockingly, the nominees, including the future Solicitor General, John Sauer, refused to give an unequivocal response. Now, days ago, Mr. Sauer faced the same question, and he repeated this legal dodge before the Supreme Court of the United States. During arguments in a case challenging the president's illegal birthright citizenship executive order, Justice Barrett, known as a Trump nominee, asked Mr. Sauer if the administration would follow circuit court rulings. Mr. Sauer responded that the governor's policy is to, quote, generally respect circuit precedent, but not necessarily in every case. As our colleague Senator Kennedy said earlier this year, and I quote, don't ever take the position that you're not going to follow the order of a federal court, ever. Mr. Gaiser has been nominated to lead the Office of Legal Counsel, which provides legal advice to the President and all executive branch agencies. I want to hear what he believes that the policy of the federal government should be and whether he can ignore court rulings that don't suit any president's whim. From day one, the administration has had one goal: bringing our immigration system to a breaking point. I will confess some prejudice in this matter. I am the son of an immigrant who came to the chairmanship of this committee. I'm proud of it. If you visit my office, you're going to find my mom's naturalization certificate behind my desk, making it clear to all visitors where I stand on the issue of immigration. I like to believe that my family and virtually all of the immigrant families have made this a stronger nation. Beyond unlawfully attempting to end birthright citizenship, which is enshrined in the Constitution, the administration has made it harder for legal immigrants to apply for citizenship and naturalize. This administration has made it harder for dreamers who want to do the right thing. Now, these were kids brought to the United States by their parents. They didn't make a conscious decision to get in the car and drive across the border. Their parents did. They've grown up here in the United States, showed up in the classrooms and pledged allegiance to the same flag we pledge allegiance to every day. It wasn't until they were teenagers that they knew the real reality that they face. They want to do the right things. They want to apply for programs like DACA so that they can receive work permits and continue to contribute to the American economy. I'm disappointed to hear that Mr. Edlow, who came by my office, nominated to lead USCIS, opposes DACA, when even President Trump claims that he doesn't want to deport dreamers. Despite his personal opinions, I want to hear how Mr. Edlow will ensure that USCIS will promptly process DACA applications of eligible dreamers. The administration has also ended temporary protected status for people who fled Afghanistan and Venezuela, falsely claiming these countries are safe to return to. These actions are cruel. In the name of carrying out Trump's mass deportation agenda, Attorney General Bondi has made the Department of Justice a shell of its former self. Thousands of federal law enforcement agents have been diverted from drug trafficking and violent crime to deporting immigrants who pose no threat to our safety. Mr. Woodward, nominated to be the number 3 official of the Justice Department, will oversee Justice Department grant making, the Civil Rights Division, and many other components now under attack. The Justice Department, at the direction of DOJ, took their chainsaw to hundreds of millions of dollars in federal grants to support public safety and our police. Programs supporting violence reduction, victim services, child protection, and substance use and mental health have been gutted. Ask law enforcement in your favorite community how you stop crime. They have an important job to do, and we know that. When we dial 911, we want to make sure that the right person is answering the call. But they will also tell you we cannot arrest our way out of violent crime. We need to do more. I believe that. For nearly 70 years under Republican and Democratic administrations alike, the Civil Rights Division protected the civil and constitutional rights of all Americans. Once known as the crown jewel of the Justice Department, it has now been reduced to litigating a narrow set of cases aligned with the MAGA agenda. This is anathema to how this division has operated historically. I want to hear from Mr. Woodward whether the Justice Department will continue to capitulate or will it help restore the Justice Department's intended function, protecting the safety and rights of all Americans. Thank you, Mr. Chairman.
Now, in this order, we'll hear from Senator Moreno, Tillis, and Moody to introduce the nominees. Senator Moreno.
Chairman Grassley and Ranking Member Durbin and members of this committee, Judiciary Committee, it is my absolute honor to introduce to you T. Elliot Gaiser as President Trump's nominee for the U.S. Assistant Attorney General for the Office of Legal Counsel. Mr. Gaiser currently serves as Ohio's Solicitor General, and of course, we all know Ohio is the greatest state in the country. He has zealously advocated for Ohio and its citizens. As the state's Solicitor General, he represents Ohio and its agencies on the appeals in the United States Supreme Court, the U.S. Court of Appeals for the Sixth Circuit, the Ohio Supreme Court, and other state and federal courts. He has served the state remarkably And I am so proud that President Trump took well-deserved notice of Mr. Gaiser's brilliant legal talents. Immediately prior to his appointment as Solicitor General, Mr. Gaiser worked in the issues and appeals practice at a global law firm. In private practice, he focused on appeals and provided strategic counsel to clients in a range of industries regarding litigation and regulatory matters. He has litigated complex disputes all over the country. And in Ohio, Mr. Gaiser clerked for Associate Justice of the Supreme Court Samuel A. Alito, for Judge Naomi Rowe of the U.S. Court of Appeals for the D.C. Circuit, and Judge Edith H. Jones on the U.S. Court of Appeals for the Fifth Circuit. Mr. Gaiser started his legal education at the National Championship, Ohio State University, Moritz College of Law, and earned his J.D. from the University of Chicago. See, ranking member, we'll give you some credit as well. College of Law in 2016. He received his undergraduate degree from Hillsdale College, where he graduated magna cum laude. He's 35 years old. So this is all something he's accomplished in such a short period of time. And on a personal note, to the ranking member's comments, I appreciate that very much. And if you come to my office, you'll see my H-1B visa. You'll see my naturalization certificate. I was extraordinarily proud. One of the moments I remember more than anything else in my life was the ability to raise my right hand and pledge allegiance to the United States of America and be welcomed to this country. I would ask you and all the members of this committee to understand that that moment is so important. And we have to honor the people who followed the law to come here legally, who patiently waited to become a U.S. citizen and be welcomed here, and to stop rewarding people who break our laws, skip in line of those in front of us. And I can tell you that I have no doubt that Mr. Gaiser will continue to make not only Ohio proud, but this nation proud as he serves President Trump and Attorney General Bondi as the United States Assistant Attorney General for the Office of Legal Counsel. Thank you.
Thank you, Senator Moreno, and you may go if you want to. Senator Tillis.
Thank you, Mr. Chair. I'm pleased to introduce John Squires, the President's nominee for the Undersecretary of Commerce and Secretary of the U.S. Patent and Trademark Office. When I first met John, I told him that the USPTO needed a fierce advocate for strong IP rights, and after a review of his record, I am convinced that he is the right person for the job. John and I trace back similar roots. He was at IBM before becoming a lawyer. I was at IBM before I made the fateful decision to go into politics. There are several things in experience, though, that I think you'll see in the confirmation hearing today that make him very well suited to lead the USPTO. John's a 9/11 survivor, and that's greatly shaped his perspective on patent eligibility, and I'm sure that we'll get into that during the hearing. Like me, he believes that startups and emerging companies are critically important to our innovation ecosystem. And I believe that he can bring expertise to the office that will make sure that that segment of our innovation economy is well represented. For example, small businesses, firms having less than 10 employees receive about 60% or more of the patents per capita than corporations. And startups and small businesses create almost half of all the U.S. jobs and growing. That is why we absolutely have to get this right, so that the pyramid of our innovation ecosystem stays strong. John's also a consensus builder. He's gotten great reviews from prior directors of both political parties. That's important for the work that we're doing here. I've said multiple times in the IP subcommittee, I love the subcommittee because it's an island of calm in a sea of chaos at the main committee. We work on a bipartisan, bicameral basis, and I think John is going to be a great asset in that role. America innovation needs a champion dedicated to ensuring that this country maintains strong, reliable, and predictable patent rights. We, the United States of America, must remain the innovation leader in the world. And I believe that John Squires will bring the leadership to the USPTO to make sure that we accomplish that end. I strongly support his nomination, and I look forward to asking him a number of questions. And by the way, to the little baby, I will tell you all what I've said to others. As a grandfather and a father of 2 kids, nothing is more beautiful than the sound of someone else's baby crying. I fully support Mr. Squires' nomination.
Senator Tillis, thank you. Now Senator Moody.
Thank you. And I'm now, as one of two senators who are moms of kids in school, I think it's also a good distraction tactic for mothers, because all I wanted to do was run over there. So my Democrat colleagues, be on notice if you ever want to distract us, pack the room with babies. Good morning. It is my honor to be here today to introduce President Trump's nominee to be the next director of the United States Citizenship and Immigration Services, USCIS, Joseph Edlow. Mr. Edlow's nomination comes at an extremely critical time in our nation's history. As Florida's Attorney General, I sat aghast as one of the first actions of Biden and his administration was to tell our local and state officers to stop, that there will be no more detainers and that they were to just release everyone here committing crimes back into our communities. They then at one point started taking people that were finishing federal prison sentences, and instead of deporting them back home as had always been traditionally done, pushing them back into our communities. And as the borders were open and mass quotas were installed in terms of pushing people into our interior that were barely vetted, and as new programs were developed to fly people straight here, barely vetted, it became abundantly clear as we saw the aftermath and consequences of that, that a strong vetting system, indeed a strong USCIS and someone at the helm, was critically important to this nation's security and indeed our families' securities. We have experienced over the last 4 years watching millions, some say upwards to 20, but at least 11 million people fled this country. We don't know who they are. We don't know in many cases their criminal backgrounds, although we're figuring that out now, and now we see why it is so important that it wasn't that we just needed to seize operational control of the border, and I'm so grateful for President Trump for doing that. It is now so important that our legal immigration system function as it was meant to, and that is screen and vet and guarantee that the safeguards and laws we've put in place to make sure that those that are coming here are coming because they want to add and contribute to this country. And they do so legally. It is so important we have someone at the helm to make sure that happens. The Director of U.S. Citizenship and Immigration Services is responsible for leading the charge to screen and vet those coming to our country legally, and I know Joseph Edlow is the right man for the job. In fact, he's already done the job. He graduated law school and began his legal career as an associate attorney. Mr. Edlow joined U.S. Immigration and Customs Enforcement, or ICE, and in 2008, as Assistant Chief Counsel in Baltimore Office of Chief Counsel, he litigated removal matters and handled every type of immigration case within the jurisdiction of that court. In 2015, Mr. Edlow then worked in the House of Representatives, first as counsel, focusing on immigration, and then for the House Judiciary Committee, Subcommittee on Immigration and Border Security. As counsel, he worked on legislative and policy matters related to immigration enforcement and criminal immigration law. In 2018, he joined the Department of Justice as a Deputy Assistant Attorney General, where he was responsible for DOJ's regulatory agenda for all immigration matters. And in 2019, he became chief counsel for USCIS, later serving as deputy director for policy, and then as acting director. I cannot think of anyone more qualified to take on this job. And in fact, putting people in these roles who did not have that type of experience or expertise would be dangerous for the country at this moment in time. And given his extensive experience, I have no doubt that he will do an excellent job as the next director of USCIS. And after my conversation and my meeting with him, I'm even more convinced that he will hit the ground running on day one and do what we have to do right now, working with President Trump to clean up the mess of the last administration and indeed deliver an immigration system that is meant to work as the people intended. He has my full support. I hope my colleagues will feel the same, and it is my honor to introduce Mr. Joseph Edlow.
Yeah. Thank you, Senator Moody. Will the nominees please come to the table and don't sit down because I want to offer oath. Okay. Do you swear that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. I saw everybody say yes. Please be seated. It's our tradition, we'll start with Mr. Edlow, but for all of you, it's our tradition that if you want to introduce family and friends, before you give your opening statement. That's okay. Now you may proceed, Mr. Edlow.
Mr. Chairman, thank you so much. Chairman Grassley, Ranking Member Durbin, and distinguished members of this committee, thank you for the opportunity to present testimony today regarding my pending nomination to serve as the next Director of U.S. Citizenship and Immigration Services. It is an honor to appear before this esteemed committee, and given the very productive conversations that I had with many of you prior to today, I am looking forward to discussing my vision for USCIS and the legal immigration system of this great nation should I be confirmed. I want to first thank President Donald J. Trump for this great honor and for the trust that he has placed in me through the nomination. I would also like to thank Secretary Kristi Noem for her outstanding leadership of the Department of Homeland Security and her commitment to immigration enforcement, border security, and the rule of law. It would be a privilege to serve as the next director of USCIS in such a vibrant and stalwart administration. I also want to take this time to acknowledge my family, as well as professional and personal colleagues and friends, several of whom are in this room, who have provided endless support during the confirmation process, as well as throughout my personal and professional development. First and foremost, thank you to my wife, who has stood steadfastly beside me and still laments that she can cite the Immigration and Nationality Act verbatim after years of endless conversations. My 2 children, who are the lights of my life and my primary motivation for my calling back to public service, and my parents, who have provided me with the foundation that has ultimately led me to this moment. I would be remiss if I didn't mention my 2 legislative mentors, Raul Labrador and Bob Goodlatte, as well as my colleagues at the House Judiciary Committee Immigration Subcommittee, who serve as my immigration compass and a never-ending source of friendship and professional camaraderie. The United States sits at a critical crossroads on the issue of immigration policy. As I've written and testified repeatedly over the past 4 years, the Biden-Harris administration waged a war against the immigration system with the results speaking for themselves. The immediate impacts of unchecked illegal migration and border incursions since 2021 had tremendous impacts on the ability of USCIS to carry out its core functions. The misplaced priorities and reassignments of resources to support unlawful border activity has left the agency with backlogs that are unprecedented and beyond anything that was ever previously contemplated. While the situation is dire, the immediate and decisive actions taken by President Trump, Secretary Noem, and others within the executive branch have stemmed the tide, and we are now enjoying some of the lowest daily, weekly, and monthly border numbers in American history. With CBP's success at the border and the tremendous work being done by ICE in interior enforcement, the time for decisive action within our legal immigration system is now. If confirmed, my vision for USCIS is simple. I will restore integrity within the legal immigration system. While the whole Department of Homeland Security is working hard to make America safe again, USCIS must play as critical a role in that mission as any other immigration enforcement agency. At its core, USCIS must be an immigration enforcement agency, an agency that is dedicated to ever-evolving and innovative techniques for screening and vetting its applicant pool. An agency that must be vigorous in its efforts to detect, deter, and disrupt immigration fraud, threats to our national security, and to the safety of the American public, and to ensure that only those aliens deserving of the honor to become citizens of this great nation are able to exercise the sacred right to vote. These core missions will make America safe, while also aiding us in more rapidly and more confidently adjudicating cases, will lead to a significant reduction of the agency's backlog, and will put American interests first. For the last 4 years, USCIS was referred to as a welcoming agency. While we should absolutely be a welcoming agency for eligible aliens into this country, make no mistake, my oath will always be to the Constitution, as I will act to faithfully enforce the laws as Congress has prescribed them, and will always put the interests of the American people before all else. Under my leadership, we will not only safeguard our nation's immigration system, but also serve our integral role as an agency committed to protecting the homeland and safeguarding our nation. I look forward to working with the very dedicated workforce at USCIS to accomplish these goals. I thank this esteemed committee again for its attention to this confirmation process, and I welcome your questions. Thank you, Mr. Chairman.
Thank you, Mr. Edlow. Now, Mr. Gaiser.
Thank you very much, Chairman Grassley, Ranking Member Durbin, members of the committee. Thank you also for the kind introduction, Senator Moreno. Before I go any further, I'd like to recognize a few people who are here with me and those who couldn't be here. First and foremost, my beautiful wife, Alexandra, who's the most intelligent woman in any room. My 3-year-old son, Elijah, and 11-month-old daughter, Allegra. I think you've all met her. My father-in-law and mother-in-law, Alan and Stephanie Harrison, who are celebrating their 37th wedding anniversary today. Thank you so much for being here. And my mom and dad, Linda and Brian Gaiser. I wouldn't be here without you. You raised me and my siblings, Jeff and Ari, who are also watching from home, to love this great country and thank God for our freedoms. Who could have imagined raising us in that little brick house on West 138th Street in Cleveland, that someday your son would have the honor to testify before this esteemed committee? I would not be the lawyer I am today without the incredible jurists I had the honor of serving as a law clerk, Judge Edith Jones, Judge Naomi Rao, and Justice Samuel Alito. Your kindness and concern for the ordinary American is matched only by your brilliance and strength of character, and I hope to live up to your examples. Thank you also to Attorney General Dave Yost of Ohio, who's entrusted me the role of his Solicitor General to represent Ohio before the Supreme Court and beyond, and to assist with his statutorily authorized power to issue formal advisory opinions on Ohio law. And though I believe they are now in a better place, I wish to remember Ted Olson, who did his best to impart some of his kindness and wisdom to me when I was a young lawyer, and Ambassador Boyden Gray, whose mentorship to me when I was just one of 4 lawyers at the law firm he founded will leave, I hope, a generational legacy. Most important, I am grateful to President Trump for nominating me. It would be the honor of a lifetime to execute the duties of Assistant Attorney General for the Office of Legal Counsel. The functions of OLC date to the Judiciary Act of 1789, and it is served to uphold the rule of law and the separation of powers into the modern era by issuing opinions and answering legal questions according to the best reading of the law. In that sense, OLC reinforces a critical piece of American exceptionalism. One past head of OLC, Justice Antonin Scalia, often remarked that many despotic nations had eloquent bills of rights, but those parchment lists were worth less than the paper they were printed on. Why? Those nations did not enjoy the structure of the American government, the separation of powers and federalism, without which flowery lists of individual rights meant so little. Thomas Hobbes described the government as a leviathan. That's a Hebrew etymological word which means that which gathers itself up in folds. And indeed, for most of human history, government matched that description. But in 1776, with a reliance on the protection of God's providence, our forebears revolted against the encroaching folds of empire. The Constitution they established runs with the warp and woof of human nature, where ambition counteracts ambition, where the atom of sovereignty is split between the states and the federal government, and where representative democracy ensures public service is always a public trust. The separation of powers in federalism ensures American government is more than smothering folds, but rather responsive to the whole people, including the forgotten men and women who desire only safety in their communities, security on our borders, growing, not tightening family budgets, and laws not weaponized against political enemies, but even-handedly applied to all. I'm proud to have fought in court to defend these principles, first as a litigator in private practice, and now as the Solicitor General of my home state. And should I be confirmed, I will devote every day to providing my best advice and counsel on the best reading of the law at the Department of Justice. Thank you very much.
Thank you, Mr. Gaiser. Now, Mr. Squires.
Thank you, Mr. Chairman. Thank you, Chairman Grassley, Ranking Member Durbin, and members of the committee. I'd like to thank the chairman for the opportunity to introduce my family. Before I open statement, I'd like to introduce my lovely wife, my beautiful wife, Mary Lou, of 33 years, my lovely daughter, Elizabeth, my handsome son, Will, both of whom are proud alums of Camp Invention, and my friends and colleagues who have supported me over the years, including Professor John Duffy, who's with us today. It's my honor to be here today, and I'm, of course, grateful to President Trump, to whom I was introduced to by an inventor, and Commerce Secretary Lucknick, the department's very own New Age Edison with over 400 patents. I appreciate their trust and confidence in nominating me for the Undersecretary of Commerce and Director of the United States Patent and Trademark Office. My intellectual property awakening began, as Senator Tillis mentioned, not with my chemistry degree, but rather with IBM in marketing. Back then, it was IBM versus Japan Inc., and IBM won because of patents. With my new patent and law license in 1993, the robust frontier of IP opened up. As to patents, I started out in the traditional realms of chem and biopharma materials and manufacturing. Then it was on to the internet, building fintech and regtech disruptors. Most recently, it's been the leading edge of AI, crypto, and quantum computing. With the onrush of technology, it's always on to the new and the next. As to trademarks, from scholarship on free speech, to NFTs, to standing athwart the name, image, and likeness earthquake, it's been equally remarkable. Since 2000, in bringing my practice to Wall Street, I've sought to better our system. And as a survivor of 9/11, in me you'll find no fiercer defender of national security, tougher enforcer of good faith and fair dealing, or eager proponent of free market solutions. In the wake of 9/11, Secretary Lutnick, as you know, courageously rebuilt his company with patents. For me, patents became the tip of our private sector spear in America's soft power war against terrorist financing with our partners in the CIA, FBI, and Treasury. We humbly received an FBI Director's Award almost a decade later. Armed with our inventions to combat terrorism, we barged into the patent eligibility debate and were ultimately successful as Supreme Court amici. I've humbly chaired industry subcommittees, taught at UPenn, testified to the FTC, and co-authored a federal trial judge bench book on complex patent damages. But most notably, it's truly a special honor for me to be here today for a second time, proudly now as a nominee, having testified almost 20 years earlier to then Chairman Leahy. Finally, for the last 8 years, I've helped startups use their IP to attract investment, commercialize their products, and create jobs. I couldn't be more excited to join the Commerce Department, as I believe the breadth of my experience will help lead our remarkable unitary systems efficiently into the future. To succeed, though, we'll need to have a commercially compelling answer to the question, why come here? To answer that, we must ask what we want from innovation. We want it to be better, cheaper, faster, more sustainable, to get us to market more quickly, with quality and confidence. At present, unfortunately, our system is going in the other direction. But with born strong patents and robust quality marks, we can reclaim America's primacy, revitalize industry and growth, proudly export our culture, boost national security, and improve our lives. We well know the issues, namely pendency, patent quality, and uncertainty. And while the solutions are at hand, there's a danger too. AI tools are being amassed that could easily overwhelm the system. However, if harnessed, these tools can deliver our finest hour. By leaning into AI, the burgeoning asymmetry can disappear. We can equip our world-class examining corps to grant patents tested by those same fires, expeditiously issued, and of provable quality. And we'll use these very same tools to learn from, reduce, and remedy mistakes that manifest later. I believe I'm uniquely prepared for this role. It's said that every patent begins its life as a trade secret. We want inventors from every conceivable walk to bring their inventive raw materials to our American patent factory, where we'll help them hone and hew new, strong proprietary rights that are the building blocks of dreams, where they are rewarded and society advances just as the Constitution intended. As you can tell, I'm very bullish on the chapter ahead, and for a very bipartisan reason. Patents aren't red, patents aren't blue. Upon government grant, they are red, white, and blue. They are the best of us, extol our wares, and foretell a future of American ingenuity unleashed for all the world to see. Brilliant computer scientist Alan Kay once said, if you want to change the future, invent it. We need to get to work. Today, I humbly ask for every member's consideration and support for my nomination. Thank you, and I look forward to answering your questions.
Thank you, Mr. Squire. Mr. Woodward, I want to apologize to you. When I got done introducing you, I wasn't done. I only said half of it, so I realize now I'll put the other half in the record so you get fully introduced to the committee. Please forgive me.
Mr. Chairman, no apology necessary. Thank you for that very kind introduction. Chairman Grassley, Ranking Member Durbin, I appreciate this opportunity to address the committee. Thank you to the committee members and staff who took the time to meet with me and to discuss the thoughts and concerns about the challenges facing our nation. If confirmed, I look forward to working together with you, the leadership of the Department of Justice and the leadership of the Trump administration to address these challenges. To quote another, I stand before you on the shoulders of giants. I would not be here but for so many who have taken the time to serve as mentors throughout my personal and professional development. To my family, mere thanks is wholly insufficient. You have endured a great deal on this journey and never asked for any of it. Senator, sometimes actions speak louder than words, and today I'm privileged to be joined by nearly every senior attorney at the Department of Justice to be appointed by the Attorney General. It has been an honor to work by your side in the trenches these last few weeks. Senators, I have long believed that as attorneys, we have a duty of service to our community. To so many, the law is beyond understanding. And so with the ability to learn the law comes the responsibility to use that gift for a greater good. Nowhere is this belief more poignant than at the Department of Justice. If confirmed, I pledge to seek justice for all. I submit that my professional journey serves as evidence of my commitment to this pledge. Beginning in law school, I felt this calling. Classmates and I traveled to Biloxi, Mississippi to volunteer in the wake of Hurricane Katrina. This trip profoundly changed my view of the role of the law. Door to door, we went meeting with families living in trailers, advising them of the federal assistance available to help them rebuild. My colleagues would visit 10 or 12 homes a day. I often managed only to visit 1 or 2. As I sat on makeshift porches, sipping iced tea, looking at pictures of what was lost, I came to realize that if given the opportunity, I would do good with my ability to learn the law. For these people did not understand, did not know that they could apply for federal assistance. They did not know. It was in part this desire to serve my community that motivated me to found and lead the housing law practice at the firm where I practiced. There, I led teams of attorneys in defending tenants with housing code violations facing eviction. That experience was equally enlightening because they did not know that they could not be evicted where there were housing code evictions. This simple concept was foreign to them because the law was foreign to them. I say in part because I also pursued that work to find opportunities to appear in court. Senators, I went to law school to be in court. And so when I founded my own law firm at the height of the pandemic, it was natural for me to seek out additional opportunities to appear in court. I applied and was appointed to the Federal Criminal Justice Act panel here in the District of Columbia, where I would be appointed to the court, by the court, to represent criminal defendants. At that time, the Department of Justice was in the midst of its largest ever investigation, prosecuting thousands for their involvement in the events of January 6. I was surprised to see that so many were unwilling to represent these defendants. I was reminded of John Adams' famous observation in his defense of British soldiers. Facts are stubborn things. I would also be remiss were I not to observe that while the media may have been focused on the weaponization evidenced in the case I'm perhaps now best known for, the defense of Walt Nauta in the so-called Florida Documents prosecution, the tactics that were employed there were present in many of the cases I had with lesser national import. Across my practice, I saw firsthand how the power of government can be abused. Senators, there is no place for weaponization in our government. Although I know the journey may be fraught, I am inspired by those who have led us to this point. To President Trump, thank you for your nomination to this post. Your trust in me will not be taken for granted. As I sat at counsel's table with you, the former president, a defendant in a courtroom, I watched as you persevered when many would have faltered. Our journey here today calls to mind President Teddy Roosevelt's now famous colloquy. It is not the critic who counts, not the man who points out how the strong man stumbles or where the doer of deeds could have done them better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error and shortcoming, but who does actually strive to do the deeds, who knows the great enthusiasms, the great devotions, who spends himself in a worthy cause, and who at best knows in the end the triumph of high achievement, and who at the worst, if he fails, at least fails while daring greatly. Senators, if confirmed, I pledge to dare greatly. I look forward to your questions.
Thank you, Mr. Woodward. I'll start with, we have 5-minute rounds. I'll start with Mr. Edlow. H-1B abuse has been a priority and significant concern of this committee. Senator Durbin and I have bipartisan bills that would crack down on H-1B abuse that we are working on to reintroduce very soon. Recently, many Americans took to social media to express their outrage over H-1B abuse. They even shared personal stories about being laid off by big tech, even as their employers continued to hire H-1B workers. So, how would you fight fraud and abuse in the H-1B program when you become director?
Mr. Chairman, thank you for the question. In terms of fraud and abuse in the H-1B program, it is absolutely pervasive, and it's something that in the first administration we attempted to handle via regulation. Unfortunately, that regulation was vacated. If confirmed, I look forward to moving forward with additional regulations and sub-regulatory actions, but also I do have to commend you and Ranking Member Durbin for introducing legislation to bring attention to this critical issue, and I want to be a partner, if confirmed, with both of you to fight this however we can. And it's more than just the H-1B system. Frankly, we need to be focused on the fraud, waste, and abuse that we have found in every non-immigrant and immigrant program that needs to be addressed at this point.
We have to take care of that fraud in order to get some increase in numbers that people desire. Mr. Squires. I'm troubled about the growing industry whereby financial institutions engage in third-party litigation funding, including IP litigation funding. While you were in the private practice, you helped create Fortress Investment Group IP funding arm. I understand that Fortress Investment Group commits billions of dollars each year to fund IP litigation. Please explain the role you played in the creation of Fortress and your professional and financial involvement with that group since its creation, and have you supported or represented other IP litigation funders?
Thank you for the question, Mr. Chairman. In reverse order, I have not represented Fortress since about 2017, 2016, 2017 or so. And have never represented litigation funders in any capacity. I have no arrangements with them, financial or otherwise, since my representation, legal representation of them. This is certainly a question in litigation financing is a bit of a misnomer insofar as issues of which there's been much ado about with my work. My work for Fortress at the time was before they were acquired. It was a group that came to me around 2012 regarding legal papers and theories I had developed about patents as derivatives and patents as assets per se to be valued on their own fundamentals and economics. In fact, I've been rather tough on trolls in some of my writings because troll practices are exploitive of inventors. They generally are not based upon the fundamentals and are arbitrage play, whereas our patents, patent theories with them as assets per se allow companies to monetize their patents. So they came to me with an issue wanting to solve a problem of how a company could monetize its patents without selling them, without suing, and without licensing them. We developed effectively a patent mortgage where the company could borrow against its patents as collateral and use the proceeds to fund working capital. Those were several companies who were their clients initially that staved off bankruptcy as a result of this. And I was pleased to see in 2021, one of the deans of the patent bar, Marshall Phelps, wrote an article where companies use this construct to survive COVID.
Mr. Gaiser, I got 35 seconds left. District court judges have been issuing unprecedented number of universal injunctions to try to block President Trump's immigration policies. I think you spoke to the separation of powers, but let me ask you anyway, in our constitutional system, who has the primary authority for protecting the borders and setting immigration policy, and what is the proper role of district courts in resolving immigration disputes?
Thank you very much, Mr. Chairman. Congress makes the laws, and the President executes those laws to secure our border. District courts have authority under Article 3 to adjudicate cases and controversies.
Okay. Senator Durbin.
Thank you, Mr. Chairman. I believe, and many of us do, that we are on the cusp of a constitutional crisis, an historic moment. The Justice Department is currently defending the Trump administration in a number of lawsuits challenging executive actions taken by the president and officials of his administration. Federal judges, both Republicans and Democrat appointees, have enjoined some of these actions, holding that they are illegal or unconstitutional. Alarmingly, President Trump and his allies, even some nominees before this committee, have responded by questioning whether the executive branch must follow court orders. If confirmed, you will hold key positions in the executive branch and you will take an oath to uphold and defend the Constitution. So my question I ask of each of you is this: if, after exhausting all rights of appeal, do you believe a litigant, including officials in the executive branch, can lawfully defy a court order? Mr. Woodward.
Thank you. Thank you for the question. I do take issue with the premise of the question insofar as district court judges are not holding that President Trump's orders are illegal or unconstitutional. The only ask of district court judges at that time is whether there is a likelihood of success on the merits.
If you would stick to my hypothetical, it is an approach that is very clear. I don't want to argue a different issue. I'd like to argue this issue.
To your question, Senator, the president has made clear that he will follow any order of the Supreme Court.
Do you believe that officials in the executive branch can lawfully defy a court order? Yes or no?
Senator, the president has been very clear that he will follow any order of the Supreme Court.
No response. Mr. Squires?
Thank you, Senator. In my world, which is generally governed by Section 8, Clause 8, Section 1, Article 1, Section 8, Clause 8, excuse me, the Patent Office is an ex parte body, and generally there are appeals from executive actions taken by the director, and there is a lone court of appeals, unlike the circuit system, for the Federal Circuit, and then up to the Supreme Court. So patent issues tend to be adjudicated for issues that are in dispute up to the Supreme Court, and obviously the Supreme Court precedent governs, and that would be followed.
So you believe a litigant, including officials of the executive branch, must follow a court order, cannot lawfully defy a court order?
Thank you, Senator. I believe that the Supreme Court orders will be followed by executive branch, yes.
Mr. Gaiser.
Thank you very much, Ranking Member Durbin. The President has been very clear. He will follow all court orders of the Supreme Court.
Do you believe that any executive official can lawfully defy a court order?
No.
Mr. Edlow?
Thank you, Senator. If confirmed, I will always follow advice of counsel when addressing these matters and how to handle such cases as you've raised them.
So can an executive official lawfully defy a court order?
I would defer to counsel as that. I'm not here in an attorney's role right now. I'm here as a director, or as the nominee for director.
I don't believe you need a law degree to answer this question. Can an executive official lawfully defy a court order?
Again, given the speculative nature of the question, my answer remains the same. I will always file advice of counsel.
No response. This is what troubles me greatly. If we cannot agree on this as the basic premise of our rule of law, where in the world are we headed as a nation? It should be a clear answer: lawfully defy a court order? No. Senator Kennedy said as much when he came back to this committee after a hearing in which I asked a question, and the present Solicitor General equivocated on the answer. There should be no equivocation. by Democrat or Republican, in or out of power. And yet, you hear what I run into, the evasion that I face. Mr. Squires, have you ever engaged in dishonest and dangerous activity at a law firm?
No, Senator.
Do you know what's happened to your former firm, Perkins Coie?
Yes, Senator, I have seen the executive order.
Did you read the president, or at least the administration's position on your former law firm? The executive order claimed that the firm, quote, dishonest and dangerous activity has affected this country for decades. The order further alleged that the firm is, quote, undermining democratic elections, the integrity of our courts, and honest law enforcement. Did you see any evidence of that activity when you were a member of this firm?
Thank you for the question, Senator. My role at Perkins Coie was to establish the first New York Patent Office presence. I dealt only with patent issues and intellectual property issues, and I had really no line of sight into any of the practice areas.
So you saw no evidence? I want to complete the question. Did you see any evidence of this wrongdoing that the president alleges in his executive order?
Sir, in my areas of responsibility, I saw no wrongdoing with respects to intellectual property.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Squires, thank you for being here. Actually, I wanted to go back. I think you answered the question from Senator Durbin exactly right within the lane that you would be operating for the USPTO. Would you just describe that again about how most cases move through the courts and up to the Supreme Court?
Thank you for the question, Senator, and thank you also for the opportunity to meet and the kind introduction. Yes, the patent system is a little bit unique insofar as other agencies. It's ex parte. It's not adversarial. So there are appeals that move taken from an executive branch decision that move up through the court system in a very prescribed fashion, and that is the Federal Circuit Court of Appeals, then up to the Supreme Court.
Yeah, well, my point is, I felt like your answer was characterized as a non-answer. It was a concise answer in the context of the role that you're being considered for. Patent eligibility, PERA, PREVAIL, what do you think about them?
I thank you for the question. I am very gratified to see work done in being in this area. Some of the issues across those bills are costing American competitiveness, particularly on the area of patent eligibility. I would note, especially from the IP subcommittee hearing last Wednesday, the Chinese national patent system has a more expansive subject matter area than the United States does. And that is troubling to me. It should be troubling to all Americans. Innovation.
Should it be troubling to all Americans that you can file for a patent in China anonymously?
I viewed that session, sir, and I was shocked by that. And also equally shocked by written into the laws, the requirement that the disclosure be made to the Chinese embassies. This is before a foreign filing.
What risk do we have if we don't move forward with some of these bills that are improved certainty that the intellectual property just flows elsewhere and we lose the advantage that we have today, and that gap is closing with China?
Thank you. I think that is a big risk. As I mentioned in my opening remarks, we want people to come to the American patent factory first and have a compelling reason to come here. So we're in danger of losing competitiveness, especially in subject matter areas that other countries have no problem with. I believe there are tools in our system to avoid these issues, and I believe the bills also take care of those issues. So thank you for those efforts.
Well, thank you. Mr. Woodward, just a real quick question for you. I intend to support your confirmation, but I did have a question. I know you defended some of the January 6 defendants. After your defense, did you actively advocate, go on stage, have interviews, beyond your role as a defense attorney in the space that they were being prosecuted? Have you had any public statements or any presence that would go beyond just doing the defense work, but being an advocate for them after the fact?
Senator, thank you for the question. No, sir. I make my arguments in court.
Thank you. That's the right answer. Mr. Gaiser, I believe in this concept of political physics. For every partisan action, there's an equal and opposite reaction. Under previous administrations, the OLC at times shifted from issuing authoritative determinations on legality of executive branch actions to instead essentially advocating for the legality of these actions. Neither the administration nor the OLC were well served by this shift. In other words, can I count on you to returning to the intended purpose and mission of the OLC?
Thank you so much, Senator Tillis. Yes, sir, you can.
I expected that based on your concise answer to Senator Durbin's question. Look, we've got to be the adults in the room and stop having this back and forth, or we're no better than the people we're criticizing when they do the same thing. Let me see, Mr. Woodward, I think I'm good with that answer. I look forward to supporting you all's nomination. Mr. Squires, I'm especially looking forward to getting with you and having your commitment to come and work, not in hearings. I hate hearings. They have to be done. But participating in work groups and letting us continue to do the good work of the Intellectual Property Subcommittee. And I also want to publicly thank the members of the Intellectual Property Subcommittee because we have great attendance there, which is one of the reasons why we get so much good work done. I want you to be a partner that goes out of the formal setting and into the get the work done setting. I got your commitment on that?
Thank you, Senator. Yes, you have my commitment to do my level best, and if I'm done the honor of being confirmed, as I said in my opening statement, we need to get to work.
Thank you. I look forward to supporting all your confirmations.
Senator Whitehouse.
Thanks very much, Chairman. Let me follow up on Senator Tillis's questions, Mr. Gaiser. On this committee, I lived through the OLC torture opinions, which were so bad that the administration that wrote them had to withdraw them. The warrantless wiretapping opinions, which were so bad that they created a mutiny within the Department of Justice. And with the walkback of OLC from enforcing the so-called Reagan memo, which posits that the department and OLC in particular will be a somewhat neutral arbiter in conflicts between the executive and the legislative branch over oversight. In all of those matters, the OLC became the active, as Senator Tillis said, the active partisan for the administration and not a neutral decider. If I look at your record, first, how long have you been a lawyer?
Thank you very much, Senator Whitehouse. I've been a lawyer for 10 years.
And how many of those were you a law clerk?
I was a law clerk for 3 different jurists, about a total of 28 months.
And how many of those years were spent in private practice?
I was in private practice, Senator, for about 4 years.
At the associate level?
I was an associate, yes, sir.
How long have you served as Ohio Solicitor General?
I've served since November of 2023 and currently serve as Ohio Solicitor General.
Have you ever tried a case to a final judgment?
Well, thank you very much for that question, Senator. I have worked on trial litigation teams. I have not myself been personally the counsel of record in a trial case. I am primarily an appellate lawyer and an advisor and counselor.
Have you ever personally appeared in trial court?
Yes, Senator.
Now, some time ago, you had pretty strong views about President Trump. You said that, quote, his political positions are a lot like his hair, pasted on for effect and flopping whichever way the wind blows. That he has an astonishing weakness for flattery, falling for Vladimir Putin after a few coquettish bats of the eyelashes from the Russian thug, and that he is a short-fingered vulgarian candidate. Since then, have you had a role in Donald Trump's litigation that tried to overturn the results of the 2020 election?
Well, thank you for that question, Senator. Like millions of Americans, I have seen the courage and the results that President Trump has delivered. I watched in that field in Pennsylvania as he stood after the assassin's bullet, and I hope my children look up to and live up to that kind of courage in their life.
So while in private practice, did you have a role in Donald Trump's litigation that tried to overturn the results of the 2020 election?
Well, thank you for that question, Senator. I was retained by Donald J. Trump for President Incorporated in the 2020 campaign to provide legal advice, which I did.
The former White House press secretary testified that you were one of her go-to people to advance the argument that Vice President Pence could overturn the 2020 election. Is that true?
Well, Senator, as you know, ethical obligations of confidentiality attach to any client matter. And as a former attorney for a former client, I am not going to divulge the confidential communications that I made to that client.
Just if I look at this, you don't seem to have the legal experience that most OLC chiefs have. You seem to have done a very abrupt pivot politically into the Trump camp and into election denialism. On what basis should I have any confidence that you will exert any independence or judgment within OLC if the Trump administration comes knocking on your door for an opinion and won't go down the road of we'll give you your free torture opinion, we'll give you your free warrantless wiretap opinion, and we won't bother to enforce the Reagan memo any longer? What will keep you from going down those bad roads that we've seen OLC go down?
Well, thank you, Senator Whitehouse. The first role of any lawyer is to be able to state the law as it is. And the Office of Legal Counsel serves an important role in our administration by providing a neutral opinion objectively of what the law is.
Will you do that?
Yes, Senator.
Okay, Mr. Woodward, last question. I'll re-ask Ranking Member Durbin's question a slightly different way. Under what circumstances would you recommend that the Trump administration defy a lower court order?
Mr. Chairman, I see my time has expired. May I answer the question?
Please, you should answer, yes.
Thank you, Mr. Chairman. Senator Whitehouse, I can't imagine a circumstance in which I would be called upon to advise the defiance of a court order. I've had the great privilege of working with President Trump now for many years, and I just don't ever imagine a circumstance in which I would be called upon to give advice of that nature.
Even for lower courts?
Well, Senator, at the risk of giving a legal answer, it depends.
On what?
On the nature and circumstances of the case before us.
So there are certain circumstances that would cause you to recommend to the administration that it defy a lower court order?
Well, Senator, for example, in some circumstances, in order for a court order to be challenged, an official must be held in contempt. And so, yes, it is possible that we could get there. However, I would be remiss were we to go down the path of talking about hypotheticals because, as I say, I can never imagine a situation in which I would be asked to give that advice.
Chairman, thank you for your generosity with my time. I appreciate it. Thank you all.
Senator Kennedy.
Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pin. I think you understand where a lot of these questions are coming from. Mr. Gaiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir.
You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
Is that a yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear that those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court opinion?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
no, Senator. As the president has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the.
No. I don't want to play games here, Counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I apologize. I know that there are many ways to do that, and I don't want to play games either. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a rule.
Well, you have to give notice, right?
As a general matter, yes, Senator.
And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the good cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay. Do you know what it says?
No, Senator, I do not.
I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case dealing called Loper Bright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loper Bright.
The overturned Chevron doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper Bright, ruling unconstitutional the Chevron doctrine, would it be possible, strike that, would it be prudent for the Justice Department to exercise authority under the good cause exception to the APA in the public interest and forego the rule, the notice and comment?
So, Senator, thank you. I think I now understand your question. And that is I was alluding to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make a determination.
But my point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I take your point.
I mean, the APA provides an exception.
Yes, Senator.
It's section 553. It's right there, big as Dallas. Am I done?
Yeah.
I thought that was maybe a mouse or something.
Senator Coons.
Thank you, Chairman Grassley, Ranking Member Durbin. Congratulations to your families and to you for your nominations. Thank you for your service. Mr. Squires, I'll turn to you first, and I have a series of fairly quick questions about patent policy. I am encouraged that you're willing to serve at this pivotal moment in global IP policy and appreciate your taking the time to meet with me. Earlier this month, Senators Tillis, Durbin, Moreno, and I reintroduced the PREVAIL Act. It includes common sense reforms to the Patent Trial and Appeal Board and will help make it more the fair and efficient form I believe Congress intended in the American Invents Act. Do you think the PTAB needs to be reformed? If so, in what ways? And do you think PREVAIL could contribute to those reforms?
Thank you, Senator. Thank you for your question, and thank you also for the opportunity to meet in your office. I do think there is need of reform. I think we have almost 15 years of data since the American Invents Act to see the distribution, if you will, between post-grant review and IPRs, and the data seems to be skewed in favor of one versus the other, so reform may help flatten out that curve.
There's a significant pendency problem, about 800,000 unexamined patent applications. Dealing with that will require streamlining and improving the workforce of the PTO. Reducing this backlog will require resources. One of the provisions of the PREVAIL Act would permanently end the practice of fee diversion. The PTO is entirely fee-funded by the substantial fees paid by those who seek patents. Would you oppose fee diversion at the PTO?
Thank you, Senator. We have a Commerce Secretary also who's very savvy with patents and has lived the patent life in private sector. Fee diversion, I had testified to years ago, almost 18 years ago, should end. The Patent Office should be able to keep its fees and run its system like a business. I think the fee diversion ending would be a positive thing for the Patent Office.
In eBay, the Supreme Court dramatically cut back on the availability of injunctive relief after finding a patent infringement. My Restore Act with Senator Cotton would return patent law to what was literally centuries of tradition by restoring a rebuttable presumption that a patent owner can get an injunction. What is injunctive relief? What does it mean to small inventors, and why is it significant?
Thank you for the question, Senator. Injunctive relief is basically a cease and desist order for operations, sales, manufacturing, any commercialization of a product. It's important to individual inventors because they're coming to the office with their issued patents to get an exclusive right. Right to exclude is a property right, and property right enforcement usually involves kicking out the trespassers. So that's why the individual inventors look to that provision. It also gives them the right, exclusive right as conferred by the monopoly granted by the government to practice, not the right to do anything themselves, but to exclude others. That's what the patent grant means.
In the Section 101 area, the jurisprudence about what is patentable, I think, in fact, the Federal Circuit thinks that the Supreme Court's jurisprudence has ended up getting into a box canyon that's hard to get out of. What's the impact been of critical decisions like Myriad and Alice on cutting-edge technologies like AI and blockchain?
It's created uncertainty throughout the entire process. When a patent's granted, even if they're overcome in the office, those particular eligibility objections, they're litigated and not respected rights once they're in the marketplace, and they're often, vehicles for litigation outside of the merits of infringement, whether the claims read on an accused product.
And has this hurt our competitiveness globally in terms of where cutting-edge technology patents are being filed and advanced?
Thank you, Senator. I believe it has. And as I mentioned in my response to Senator Tillis, we've seen other nations have success with more expansive subject matter. We shouldn't be so constrained.
Thank you. Thank you for your answers across a range of patent issues. Mr. Edlow, if I might, between 2020 and 2021, over 80,000 employment-based green cards for legal employment here in the United States went to waste because the then USCIS leadership didn't adjudicate them, resolve them on time, and that sparked bipartisan concern. Do you agree that wasting green cards that have been authorized by Congress is unfortunate, and these opportunities for legal employment shouldn't be missed? And as director, will you prioritize reducing unnecessary paperwork and improving processes to improve legal employment here in this country?
Senator, thank you so much for the question. You know, in the last 4 years, I've had the privilege of serving in the private sector, and I've seen the need to modernize forms in a way that I never really understood before. If confirmed, I plan on making major gains to modernize our systems, both for vetting and screening purposes, but also to allow attorneys to better send in forms as opposed to still using paper forms, to be able to scan them and then that information be taken in through a PDF process. So absolutely.
Thank you. Last question, if I might, Mr. Chairman. I've been gravely concerned about recent decisions to abruptly end TPS provisions for folks who came to this country under these legal programs from Haiti, from Venezuela, in particular from Afghanistan, and that are leading to hundreds of thousands of people losing their current legal work authorizations at the same time. Businesses in my state and around the country are facing significant labor shortages, and families that are here legally, working legally, are facing a return to countries that are not demonstrably any more stable than they were when they left. As director, would you work to prioritize getting those who are eligible for other pathways to remain here and to work here legally the opportunity to do that, to limit the damage to their lives and to their community?
Well, Senator, let me start with commending the work of the administration right now in terms of following the law with how TPS is supposed to be. The Secretary is required to make determinations at certain intervals, and if the conditions that led to the initial TPS decision are no longer met, then they need to be terminated. Regardless of that, when someone's here with TPS or another temporary pathway, those are temporary pathways. And if they have
I'm familiar with the process, sir, and I'm also familiar with the ongoing circumstances in both Haiti and in Afghanistan, and disagree with the determination that we should force back to Afghanistan anyone who came here legally.
Mr. Chairman, if I may.
Senator Britt.
Yes, why don't you go ahead, Mr. Edlow, and respond?
Thank you, Senator. Senator, all I would say to that is I understand that I'm not going to comment. I think it'd be inappropriate for me to comment on any case that's pending right now with federal litigation. That said, certainly as temporary programs exist, there are permanent programs such as seeking asylum or other humanitarian protections, and I would suggest that someone who came in on a temporary program who feels that they cannot go back because of a reason that would lead them to need protection should apply for those protections.
Thank you,
Senator,
sir.
thank you so much.
Got it. We'll go ahead and continue with you. Thank you so much for taking time to meet with me. I'm obviously very impressed by the different roles that you've served in the department in which you seek to run. Knowing your previous work, what do you see as your vision? What are your big priorities, if you are confirmed?
No, thank you, Senator. I think the big priority has to be the reduction of the backlog.
Okay.
That backlog has grown to insurmountable levels over the last 4 years. When I left as the Deputy Director of Policy in January of 2021, there were about 450,000 affirmative asylum cases pending around the country. That number has grown. There's over 1.5 million now. Now, what does that mean? That means that all these extra people have gotten into the pipeline, and that's only for asylum. Mm-hmm. We also have green card backlogs and other, as the senator alluded to, other employment-based green cards that we need to look at too. However, the real problem that I see is I don't know who's in the backlog. For me, backlogs are more than just a bipartisan talking point about how we got to get the agency in order. I think it's of course important to get someone's benefits to them as quickly as possible so that they have this certainty, and if they're able to begin a life in the United States and assimilate, that's fantastic. If not, they need to know that certainty and to move forward. However, the real problem with the backlog is that we don't know who's in the backlog because of the lack of screening.
How do you propose we find that out?
Well, again, utilizing existing and emerging technologies, more reassignment of individuals, moving the Fraud Detection and National Security Division within USCIS out of the shadows to actually do its job, because at the end of the day, the backlog presents a national security and public safety
Let's
risk.
adjudicate and let's get these things moving. On that, look, over the last 4 years, I believe I have seen, which was just a terrible misuse of the presidential parole authority. When I am looking at what the Biden administration did, giving blanket parole, things like the CHNV program, where it is intended to give on a case-by-case basis, and looking at the actual ramifications of that, it gives me real concern. My question to you is, what do you plan on putting in place, or how do you plan on, addressing this, and how do you plan on approaching it if and when confirmed?
Thank you, Senator. If confirmed, we will take what steps are necessary at USCIS to assist with the other departmental partners in terminating parole programs, terminating parole, reviewing on a case-by-case the people who got parole, to look for the fraud and the sponsor petitions that we know now exist. There's a lot that needs to be done, but I find it interesting. We've been talking about following the law. This is something, the law on parole is very, very clear in my opinion. And the parole program, the use of categorical parole programs is illegal. And we've got to get back to that. Parole is fine on a case-by-case basis. It's been in the law since the 60s or the 50s. But the legislative intent for it was always severe need, humanitarian needs, or significant public interest. And that was a one-off. not necessarily supposed to be mass programs used to obfuscate the numbers
Do you
at the
think
border.
this is something where Congress likely may need to act on this issue?
Senator, there have been bills previously introduced that I think would certainly handle this on parole reform, and I would love to see another.
Absolutely. Thank you. I have just in my remaining minute, my question is for Mr. Woodward. As serving as Associate Attorney General, you will have direct oversight over the Civil Rights Division. This is something that I think is critically important. We want to make sure that everyone has the right to vote, and they also have the security and peace of mind of knowing that their vote counts. When you're looking at that, one of the reasons I actually introduced the Citizen Ballot Protection Act last Congress, and I'll reintroduce it this year, and I have a number of colleagues that have different pieces of legislation that address the same thing, is amending federal law to explicitly allow states to put in place a proof of citizenship requirement, both on federal mail-in voter registration forms and state mail voter registration forms that might be developed. I think that's a common sense way to ensure integrity of the vote, that American citizens are the ones voting in these elections. And my question for you is, if confirmed, what plans do you have to ensure that DOJ and the Civil Rights Division will work to enhance the integrity and security of our elections and make sure that the voters, the American citizens, aren't deluded?
Well, Senator, thank you for the question. I couldn't agree more. It is of critical importance to ensure that our nation's civil rights laws are enforced. If confirmed, I look forward to working with AAG Dillon and ensuring that voting rights are as respected as every other right. And so I'm confident that we will find a way to accomplish this, but also welcome additional legislation. Of course, the office does not itself promote policy. It enforces the law. And so if your legislation is passed, we would pursue that as aggressively as possible.
Thank you very much. Look forward to working with you both.
On behalf of the chair, Senator Welch.
Thank you very much. I'm not making this up. I've been recognized.
On behalf of the chair, I recognized you.
I apologize
I
apologize for distracting the senator, gentlemen.
Thank you. Mr. Edlow, a couple of questions. Number one, immigration's a mess here, and a lot of the responsibility is Congress, because there are areas where we should legislate. I agree with that, and that includes on parole. But one of the areas I'm really concerned about is ag workers. We've had some of our dairy workers picked up, and I am fully in support of hopefully bipartisan legislation that allows for our farmers to get the labor they need in Vermont. If we don't have immigrant labor, our cows don't get milked. It's just that simple. Do you have a view on a position that would reform the immigration laws that would allow for ag workers in Tennessee and Kentucky and Vermont, in Iowa?
No, thank you, Senator. I'm well aware of this issue, having worked for a congressman from Idaho. I've spoken to many people within the dairy industry and understand what they face.
So what do you think we should do?
Well, I think we do need to talk, and if confirmed, I'm happy to work with you and your staff on a bipartisan basis to figure out.
I assume that. What should we do? We have to have an ag worker a policy that allows for the ease for vetted folks who want to work on a farm to be able to do it.
Respectfully, sir, I do agree in that we do need to look closely at both the H-2A and H-2B visas as they exist right now to see whether and how they need to be updated to address the needs of these industries.
Okay, thank you. Let's see. Mr. Woodward, thank you for our visit yesterday in the office. I appreciated that. The one thing that I wanted to talk to you a little bit about today is when you had two clients in the Mar-a-Lago case, you had Mr. Nada and you had Mr. Tavares, right?
Senator, thank you for the question. I did represent Mr. Nada, and for a time, I did represent Mr. Tavares.
Right, and this is where I just wanted to get an explanation of what happened. My understanding is Mr. Tavares testified in the grand jury. The judge informed him that there may be a conflict because of the situation he faced and your other client, Mr. Nada. And at that point, he got a new lawyer. Is that right? I think a federal defender.
Senator, it's a little bit more complicated than that. And I also want to be mindful of not divulging confidences involving my former clients. But that generally tracks.
Yeah, so this is public record. Of course, I'm not going to ask you to divulge any confidences, so I am with you there. But what I understand happened is that and this is the public record, that Mr. Tavares changed his testimony from what he had said in the grand jury, where basically he was saying he didn't recall anything, to testimony where he said the boss wanted those tapes to be lost. So how did it happen that you went from, and you were being paid by a Trump PAC, as I understand it, or by a political action committee, is that correct, for your representation on behalf of both of these individuals?
Senator, I have received compensation by the State of America PAC. Yes, that's public.
Yeah, that's right. Thank you. So how did this, what happened that the testimony that Mr. Tavares had given suddenly became different testimony after he got a new lawyer?
Senator, with respect, the public record speaks for itself, and I would be remiss were I to engage in a discussion about advice that I provided any former client.
All right, but I am correct that in the public record, Mr. Tavares gave testimony that he recanted once he got a new lawyer.
Again, Senator, with the utmost respect, I think the public record says a great deal about this, and I'll let it speak for itself.
Okay. I have no more questions. I yield back, Mr. Chairman.
On behalf of the chair, Senator Moody.
Thank you, Mr. Chair. Appreciate all of you being here. It's never an easy thing to sit and stand for questions among all of my esteemed colleagues. Thank you very much, and thank you to your families. I often find these are harder on our families than it is on the folks taking the incoming questions. So thank you very much. Each of you comes with a unique background and indeed experience and expertise in the jobs that President Trump and our nation is asking you to take on. I know you could probably make a lot more money in the private sector, and I am always inspired by people who are willing to take a time out of their private practices or other endeavors that may bring them more pecuniary gain to serve this nation. And I appreciate that. Thank you so much. And we are at a time where we have an incoming administration that is having to marshal resources to deal with a mess and a dangerous situation like we have never seen, maybe outside wars. We are having to not only human resources, but the financing to deal with one of the largest influxes of folks surging into this nation. Some say 11 million, some say up to 20 million. If you take the more conservative number, that's more than the population in 42 of our states. Most of those were barely vetted. Many of them, we don't know what their backgrounds are. Many have proven to be really dangerous criminals, leading to rapes, murders, robberies, aggravated assaults. I could go on and on and on. I saw it firsthand as Florida's Attorney General and fought very hard to stop what was happening. But it became very clear that there was an intentional destruction of any semblance of security at our border. We saw this because we saw known people on the terrorist watch list and other criminals that we later found, and it was a cover-up. We had both administration, our president, a secretary putting in charge of DHS say our border was secure the whole time. So now you come in at a time where you are going to have to use the law to help remedy what we are faced with. And I am grateful for a president that came in and has tried as fast as possible to remedy the situation that we as America find ourselves in. But you are going to have to deal with what's left by somebody who's supposed to be a commander-in-chief protecting this nation. This morning I introduced an expedited removal of Criminal Aliens Act. This has been getting a lot of attention because you have an administration trying to use what law is available to them, some as far back as the Alien Enemies Act. But you have to use, I think that was in the 1700s, and people are criticizing them for that, but we are in historic, unprecedented time. So you have to use the tools that are available to you to protect this nation and its people. As the courts are trying to figure out what that looks like, many are frustrated because it appears so many of these district courts are trying to stymie this president and indeed what you will be charged with of delivering a remedy, a recovery, and the protection of our people. But in the meantime, we need to start moving here in Congress to ensure an expedited process to get these dangerous people out of here. I'm going to start with you. The person that I had the privilege of introducing, Mr. Edlow, is an act like this needed, and it can be useful to this administration?
Senator, first of all, thank you so much for the kind introduction. I greatly appreciate it. I'm aware of your legislation. I look forward to, if confirmed, working with you and with our departmental partners to see it move forward. I think it's absolutely necessary.
And as a result of all of the litigation around the nation, it is often said by some of my colleagues on the other side of the aisle that they point out that this administration has had more orders against them. As we are trying to show, this is probably because these nationwide injunctions and other decisions are certain courts trying to stymie this administration and being effective and delivering on promises to the American people to secure this nation again. One might say this shouldn't be surprising because you have an administration that's doing their job and using the law on the books in a way we haven't had to use them before because of the unprecedented, dangerous, reckless, irresponsible, some would say criminal actions of the last administration. Would you agree, Mr. Woodward?
Senator, thank you for taking the opportunity to meet with me. And as you and I discussed, I do agree. I'm very passionate about that. There is a tremendous amount of litigation in the courts right now because President Trump is doing a tremendous amount. He's being challenged, but he is also asserting his Article 2 powers in a way that no president has ever done before.
Or had to do.
And so, if confirmed, I look forward to assisting the president and professionally litigating and defending his exercise of those Article 2 powers as often as is needed.
On behalf of the chair, Senator Schiff.
Thank you, Mr. Chairman. I want to follow up on Senator Kennedy's line of question and ask a similar line of yes or no questions just to put a finer point and make sure that your answers are as definitive as they sounded. So let me start with you, Mr. Edlow. Yes or no, would you ever advise the administration that it could ignore or disregard an applicable district court order because you believe the Supreme Court will ultimately overturn it?
Senator, as I said before,
yes, just a yes or no question.
I don't believe I'll ever be
Senator,
in that position.
But you may not. But just like you answered Senator Kennedy, I want to make sure that you were not misleading anyone. So let me ask the question again. Would you ever advise the administration that it could disregard an applicable district court opinion or order because you believe the Supreme Court will ultimately overturn it? Yes or no?
I don't want to speculate, but I can't see a situation where I would advise to not follow a court order.
So your answer is no, you would never advise them to disregard a district court order, even if you thought the Supreme Court
Again,
would
I don't want to
overturn.
speak. I don't want to speak.
I just want you to be precise and answer yes or no.
I can't see a time where I would do that. No.
Okay. Mr. Gaiser, yes or no?
Thank you very much, Senator Schiff. I would advise clients to follow court orders.
Even if you believed the Supreme Court would ultimately overturn the district court?
Well, Senator, as far as
yes or no?
The answer is the same. The president has said he will follow court orders.
The same answer, yes or no?
Senator, the president has said he will follow.
You were able to answer Senator Kennedy, but I want to make sure that you were not misleading Senator Kennedy. Yes or no, would you ever advise the administration it could ignore a district court order because you believed the Supreme Court would ultimately rule otherwise? Yes or no, would you ever advise them that?
Senator, applicable court orders should be followed.
That's not my question. Yes or no?
Senator, you asked me.
Yes or no, Mr. Gaiser? It's a simple question.
Senator?
Mr. Gaiser, you were able to answer Senator Kennedy. Are you raising a doubt now about your answers to Senator Kennedy because you can't answer this question?
Senator, I would advise clients to follow applicable court orders.
Is that a yes or no?
I would advise clients to follow applicable.
Is that a yes or no? Let me repeat the question so there's no ambiguity about it. Would you ever advise the administration, you're going to be, if you're confirmed, heading the Office of Legal Counsel that helps determine whether actions are lawless or lawful, would you ever advise the administration that it could ignore an applicable district court opinion or order because you believed the Supreme Court would ultimately overturn the order? Yes or no?
Now, Senator, if I'm confirmed to lead the Office of Legal Counsel,
All right,
I would.
you're not answering the question. So I guess the answer is to Senator Kennedy, you just might advise the administration to ignore a district court order. How about you, counsel?
Thank you, Senator Schiff. In my role as director, I
Just
am not
asking yes or no.
Well, I would thank you. I wish to clarify. I'm not, if confirmed, a director. I'm not acting in a legal capacity at all. I'm part of the executive agency branch, and therefore would not be advising clients on any aspects of that.
Well, would it be appropriate in your view for anyone else among legal counsel to do so?
In general, court orders should be followed and respected. There are situations which I recall back from law school between branches.
I guess you're not able to answer the question either. Counsel, how about you?
Senator Schiff, thank you. I mean, I agree. I don't believe it's appropriate to address this hypothetical. At the Department of Justice.
Okay, so you want to revise your answer to Senator Kennedy then? That is, there may be circumstances where you advise the administration to disregard a district court of opinion because you believe the Supreme Court might rule otherwise. Is that your opinion?
As a lawyer, the answer is it depends.
Okay, thank you. Then we'll make sure Senator Kennedy is aware that you just might, it depends, advise the administration to ignore court orders.
Senator,
let me ask another question. Mr. Gaiser, would you agree that it would be unlawful for the president to accept a gift from a foreign state without the consent of Congress? Would you agree that's unlawful?
Well, thank you for that question, Senator.
Yes or no?
Whether something is lawful or not, I would always want to look.
I'm just asking you a simple question. Is it unlawful for the president to accept a gift from a foreign state without the consent of Congress? Very simple question.
Senator, as a lawyer, I would always give my...
I'm not asking you for a preamble, just yes or no.
Well, Senator Schiff, it depends on the fact...
Well, Mr. Gaiser, where is the depends on the facts of Article 1, Section 9, Clause 8, which says, no person holding any office shall, without consent of Congress, accept any present from any foreign state. That's the Constitution. Doesn't say, well, it depends, or it might, or maybe. It says, no person shall do so. Do you find that ambiguous?
Senator,
I thought you were supposed to be the strict constructionists. This is what the Constitution says. Is there an exception for $400 million planes from Gulf emirs?
Senator,
is there an exception for that?
On behalf of the chair, Senator Schmidt.
Thank you, Mr. Chair. I do wonder, though, that whether or not we should set up a chair for a straw man for these hearings, because these are all ridiculous straw man arguments. First of all, the President of the United States has said he would abide by court orders, and this administration has abided by every single court order. So this contraption that Democrats continue to try to create some faux constitutional crisis that doesn't exist, or as it was during the campaign, some threat to democracy to scare people, they ought to be ashamed of themselves, because it hasn't happened. It hasn't happened. And I want to give Mr. Woodward, you an opportunity to respond when the senator from California didn't give you the chance to respond with your answer before I go into my questions with a limited amount of time.
Thank you, Senator. I will be brief, and I will reiterate that I don't believe I would ever be asked to advise my client to defy a court order. It's not happening. And so the answer, it depends, matters, because there is litigation all across this country right now. And so we have to look at each and every case very carefully. We advise the client, and then the client acts. That is the role of the Department of Justice.
I want to, Mr. Edlow, I do want to ask, I've been raising the alarm on this temporary protected status, or TPS, for quite some time now, and the Supreme Court has just weighed in and ruled essentially that Joe Biden had really been abusing his authority, especially at the end, just sort of waving a magic wand and really abusing this process. And so there are 350,000 Venezuelans now that will not receive this temporary protected status because they shouldn't have got it in the first place. I want to ask, how will the USCIS stop automatic renewals and kick out folks whose countries do not qualify anymore?
Well, thank you for the question, Senator. As I stated earlier, the decision on whether to continue any TPS program rests with the Secretary, and USCIS would act accordingly. So depending on the country, depending on when the
well, let's use these Venezuelans.
Senator, I would hesitate to comment on anything that's under active litigation at this
okay,
point.
let's say there's another because I mean, let's say Haitians, which also fell into that. I want to know what tools, and I'm not asking you to opine on it. I want to know what tools are going to be used to enforce a lawful court order.
I understand.
To kick people out of here.
So certainly, Senator, the employment authorization cards, which are essentially the evidence of the status, are going to set to expire. The systems at USCIS, when appropriate, are turned off so that renewals are either kicked out or rejected, and then at that point, it becomes the responsibility of our sister agency, ICE, to work on the next step, which would be the apprehension and removal of any individual that remained after that period of time.
So USCIS decides who qualifies for TPS.
Well, after a TPS designation is made, USCIS would determine eligibility based on the law.
So they need to prove they've been here since the designation date and meet other rules. But the Biden administration made it with a rubber stamp, right? It totally, completely obliterated the process that was put in place. Is that your understanding?
Senator, my understanding is everything the Biden administration did with regard to USCIS was with a rubber stamp. So yes, TPS, the way in which parole was utilized, the way in which anything was utilized was a rubber stamp, while not caring about the long lines of people within the backlog that just kept growing because they weren't taking that seriously. They were reassigning resources to just handle the unlawful border activity.
Right. So what could be introduced as far as new vetting rules to make sure this isn't just being handed out like candy? What could be done?
Well, certainly, if confirmed, I'm happy to work with Congress to figure out if there are additional authorities that we need in order to move in that direction. But I really do think that once confirmed, we can take a look at things internally, turn some processes on, act both regulatorily and sub-regulatorily to take a real bite out of some of this and to actually, for the first time, feel confident in the vetting that's being done by the agency.
Thank you. Mr. Squires, I do want to ask you, switching gears, China's been ripping us off for a very long time as it relates to our IP, and I know there's a lot of concern with some of the breakthroughs they've gotten from DeepSeek. I mean, there's no IP acknowledged really if it's not being ripped off. It just isn't part of what they're and how they handle these things. What concerns do you have, or what can be done to combat Chinese IP theft? But then, as we get into these large language models moving forward, how do you view generally accepted IP laws to be, how does it work into large language models moving forward? Because you've heard some people talk about just abandoning IP altogether.
Thank you, Senator. It's quite a complicated question.
Mr. Squires, I know that it is. Could you submit that for the record? Because I'm very interested in the detailed response.
I would be happy to, Senator.
On behalf of the chair, Senator Lee.
Thank you very much, Mr. Chairman, and thanks to all of you for being here, and especially for your willingness to serve. Mr. Edlow, let's start with you. The Biden administration turned a lot of things on their heads. One of the many things they turned on their heads involves the optional practical training program, and they turned it into the single largest guest worker program, bypassing the traditional limitations, the traditional rules that would otherwise apply by operation of law on other visas like H-1B in the United States. What changes would you plan, if confirmed, to make in order to fix that issue?
Thank you, Senator. I think the way in which OPT has been handled over the past 4 years with the help of certain decisions coming out of the D.C. Circuit Court have been a real problem in terms of misapplication of the law. What I want to see would be essentially a regulatory and sub-regulatory program that would allow us to remove the ability for employment authorizations for F1 students beyond the time that they are in school.
Great, thank you. Mr. Gaiser, I'd like to turn to you next. You're an issues and appeals guy. You've clerked for 2 federal court of Appeals judges, Judges Rao and Edith Jones, two of the very best judges who we've ever had in the U.S. Courts of Appeals, and also for Judge Salito. At Jones Day, I take it you worked in the Issues and Appeals section, and that's what you do. That is exactly what we need inside the Office of Legal Counsel, in my view. Trial work is important. It's fundamental. It's essential to our system. And it's very, very different than doing appeals. So I just wanted to note that. One of my colleagues made an observation about that. To me, that matters next to nothing, how much time you've spent in a trial courtroom or in front of juries. That is not the work of the Office of Legal Counsel, which has historically been staffed quite appropriately, in my view, by people with stellar, blue ribbon, usually good appellate court experience, appellate court clerkships, and U.S. Supreme Court experience. So for whatever that's worth. Now, you're currently serving as the Solicitor General of the state of Ohio, further advancing your expertise, your knowledge, your familiarity with the appellate courtroom. As I understand it, the Solicitor General of the state of Ohio operates a little bit differently than many of the others do, and in ways that almost certainly will prepare you exceptionally well to head the Office of Legal Counsel. Tell us about that.
Thank you very much, Senator Lee. In my capacity as Ohio Solicitor General, I not only am the chief appellate lawyer for the state of Ohio, I'm also in charge of the Attorney General's Opinions Unit, where the Attorney General of Ohio is authorized to opine definitively on Ohio law to certain authorized requesters. I understand that role is very similar to the Office of Legal Counsel's historic role of opining on federal questions.
Stunningly similar, in fact. I mean, the U.S. Department of Justice operates as something of a full-service law firm, the biggest in the country, and the office that you'll be heading, should you be confirmed, is that office that provides people with advice. That necessarily requires you to have extensive appellate experience and a good ability to read how appellate courts, including and especially the Supreme Court, will respond. Mr. Woodward, if confirmed as the Associate Attorney General, in addition to being the number 3 person at the Department of Justice, you'll be the man. You'll be, in Spanish we would say, el mero mero, the law, when it comes to all of the oversight of all civil litigation, a number of other matters as well. Tell me how, in that position, if confirmed, you could help the Department of Justice rein in the burdensome, excessive regulation and the excessive delegation of lawmaking power to our executive branch agencies through the non-delegation or otherwise.
Senator, thank you for the question, and thank you for taking the opportunity to meet with us in advance of the hearing. As the Associate Attorney General, there would be a number of opportunities for us to challenge the burdensome regulations that have been imposed on our nation, on our businesses, on our people. Affirmative litigation is a critical aspect of what the Associate's Office oversees. What we see in the papers today is the defense of executive orders. What's talked less about is all of the affirmative cases that are being brought by the Civil Division, the Civil Rights Division, the Tax Division, the Antitrust Division. And so challenging unconstitutional regulations, as I alluded with your colleague earlier, would be a key piece of what I expect the Department of Justice to do.
Thank you for sharing that. And I want to follow up on that just briefly. When some people hear the word unconstitutional, they might think, understandably, that what you mean is unconstitutional in a way that's been recognized by the Supreme Court, in a way that is directly traceable as unconstitutional to a particular court ruling, or especially a Supreme Court ruling. But that's, more broadly speaking, that's not necessarily the appropriate way to view it, is it? In other words, there are certain features of the Constitution that don't always get tested. If they are tested, they're not always directly addressed by the Supreme Court. Constitutional avoidance, for example, is a means by which the court will often try to decide a case or controversy on a different ground if the constitutional question can be avoided. And so the non-delegation doctrine itself has been acknowledged by the Supreme Court, tends not to be enforced by the Supreme Court. And I would imagine that that's where Department of Justice that understands the implications of Article 1, Section 7, the fact that in order to make, modify, alter, create, or repeal a federal law, one has to follow the two-pronged formula of Article 1, Section 7, which includes bicameralism and presentment. Is that something that, that in your view, a good Associate Attorney General ought to examine?
Yes, Senator, absolutely.
Thank you very much, and I see my time has expired. Thank you, Mr. Chairman, for your characteristic generosity in letting me exceed that.
I love giving away time that's not mine, Senator Lee. So,
especially when we're talking about the non-delegate.
Exactly. It doesn't get more exciting than that.
In Provo, we speak of little else.
Senator Hirono.
Thank you, Mr. Chairman. Excuse me. I asked the following two initial questions of every nominee before any of my committees to get at the fitness to serve. So we'll start with Mr. Edlow, and we'll just go right down the line. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
No, Senator.
Never, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
I think that both Mr. Gaiser and Woodward testify that you would advise the administration to follow all court orders, correct?
Well, Senator, as I've said, it depends, and I realize that that's
Oh, it
frustrating.
depends on what the court order is? Okay, let me ask you another question then. In the Alberto Garcia case, the Supreme Court said that the administration had to, quote, facilitate his return from the El Salvador prison. He's still there. Is the administration complying with the Supreme Court's court order? We'll start with Mr. Gaiser and then go to Mr. Woodward.
Well, Senator, thank you very much for that question. As Ohio Solicitor General, I'm not now at the department, and the Department of Justice speaks through its briefs on matters that are in active litigation, and so it would be inappropriate
in your
for me to
opinion,
comment.
you're about to become the person who's going to be advising the Department of the department formerly known as Justice, as far as I'm concerned. So, what do you think? The fact that the Mr. Garcia is still imprisoned. Is the administration following the Supreme Court's order to facilitate his release?
Well, Senator,
You don't know.
As I said, I'm the Solicitor General of Ohio now. I'm not now at the department, and it would be inappropriate for me to comment on actively litigated matters because the department speaks through its filings and its briefs.
So when you actually become the person at the OLG, would you advise the administration to facilitate the release of Mr. Garcia?
Well, thank you, Senator.
That's what the court is telling him. Moving on, Mr. Woodrow, what do you think?
Well, Senator, I appreciate you giving me the opportunity to respond. It does depend. If we're going to discuss hypotheticals, what about a hypothetical in which
It's not a hypothetical. This is the Supreme Court's order to the administration. They are confronted with this order right at the moment. Mr. Garcia has not been released.
The question about following court orders is, of course, a hypothetical, and the hypothetical can be complicated. What if a district
That
court...
is why, Mr. Woodrow, I asked a specific question relating to a specific situation. Since you also don't want to respond, there you have it. And you know, you both of you are going to be in a position to be advising this administration. So I think your responses are telling. For Mr. Edlow, President Trump suspended the U.S. refugee settlement program indefinitely on his first day in office. However, on February 7th, he signed an executive order requiring all agencies to promote the resettlement of white Afrikaners into the United States. And less than 3 months later, these Afrikaners are entering the United States having completed a process that normally takes years. What changes has USCIS made to the refugee resettlement process to expedite the arrival of Afrikaners? And since if you're not there yet, you don't know, you can just say you don't know.
Well, Senator, I am there as a senior advisor, but I do not know, in that I can tell you, as far as I've seen, the process is the same as any other refugee resettlement process for USCIS's purposes.
Why is it that the Afrikaners are being expedited in terms of their being able to resettle in the United States?
Senator,
why are they being given what looks like highly preferential treatment?
Senator, the president has the authority through executive action and under the law
that's
to
because the
determine.
president feels like doing that. Okay, that's the answer. And are these Afrikaners going to be vetted individually so that nobody's coming in who, for example, shows any anti-Semitic sentiment? Are they being vetted individually?
Senator, again, I can't speak to specifics with regard to any of the individuals coming in, but my understanding is that they are being vetted for...
Individually. Yeah. I hope so, because, for example, there was one who was quoted as saying that that Jewish people are untrustworthy and they are a dangerous group. I would say that maybe that person shows anti-Semitic views. And so your testimony is that they are being vetted individually.
Senator, again, I am not currently leading the agency. I do not have a view into how they are being vetted. My understanding is they're being vetted as refugees have been vetted in the past.
There are serious concerns about why this is happening. And for example, the people who are Afghani are not getting this kind of highly preferential treatment. Thank you.
Thank you, Senator. Congratulations to the nominees. Thank you for being here. Mr. Woodward, let me start with you. You and I had a nice chat the other day. I appreciated the visit. When we were talking about the civil division, you referenced some tightening up that you believe needed to happen, and you brought up in that context the Mifepristone case. So I just want to drill down on this for a second. 2 weeks ago or so, the Department of Justice entered and filed a motion in the Mifepristone case in the Northern District of Texas. This is a Missouri case where the state of Missouri and some others are seeking to put back in place the safety protocols for the abortion drug that existed before Joe Biden removed them. The Department of Justice attorneys from the civil division filed a motion in that case seeking to have the case dismissed. Is it your understanding that that was a mistake? What's your view of this? I mean, you raised this case to me.
Senator, thank you for the question. As you can appreciate, it is long-standing policy of the Department of Justice not to comment on pending cases. Those briefs do speak for themselves. The reason I raised that case with you is because we were having I thought, very helpful discussion about the fact that litigation should be holistic, and that as the Department of Justice continues to litigate on behalf of the president, there's an obligation, a duty even, for us to communicate with those with whom we're litigating against. We should be personal in our litigation. We should speak to those with whom we are litigating, and we should try to come to an agreement. We don't always have to resolve our disputes in court.
Which did not happen in this case. Is that the thrust of it?
That's correct, Senator.
In other words, the Department of Justice did not work with the state of Missouri. I have to tell you, though, I'm surprised and concerned by the department's decision on the merits in this case. And I've said as much to your soon-to-be boss, the Attorney General. I frankly don't understand it. And I'm sure this case isn't going away. I mean, the Department of Justice said that they did not think venue was appropriate. So let me just ask you, if the states refile in another venue, is the department going to oppose the states on the merits? I mean, is the department actually going to defend Joe Biden's pro-abortion regulations?
Senator, thank you for the question. I have had discussions with the Attorney General about this case in my role as counselor to her presently. Of course, it would be inappropriate for me to comment on those discussions. What I can tell you, Senator, is that if confirmed, we would look very specifically at every case to have been filed by the Biden Justice Department and ensure that those cases are appropriate, and then also ensure that we are taking the right track in those cases. And so I'm happy to talk with you and your colleagues about that case and any other case if confirmed.
As you, I hope, know, before President Biden, mifepristone, the abortion drug, had long had a series of safety protocols attached to it ever since it was first offered in the United States over 20 years ago, including requirements that a physician be the one to dispense the drug, that a physician screen for ectopic pregnancies, that a physician be present to provide emergency care if necessary. President Biden removed all of these And now the drug is available. You don't have to be a physician to prescribe it. It can be sent through the mail. Telehealth providers from foreign countries are now providing this drug. And it doesn't matter as a consequence what any state or voters in any state decide. The voters of my state, for example, any limits on the drug imposed by voters of a state consistent with the Dobbs decision is automatically overridden by what Joe Biden's FDA decided to do. So this is a matter of extreme importance, and I just point out 70% of abortions now in the United States occur because of this drug, which can now be administered totally unsupervised. Let me just ask you, are you familiar with the Ethics and Public Policy Center's recent survey of mifepristone prescriptions? 865,000 mifepristone prescriptions over a 5-year period. Have you seen that study, Mr. Woodward?
Senator, I apologize, I have not seen that study.
Well, let me just bring you up to speed. What the study shows is that over 10% of women who are prescribed this drug, again, without physician help or aid, over 10% of these women experience a serious adverse health event. That means an infection, hemorrhaging, a life-threatening event, sepsis, that leads them to go to an emergency room. That is 22 times higher than what the FDA label currently admits is the risk of a serious adverse health event. This is the largest study of mifepristone done, I think, ever. 865,000 separate prescriptions were studied. So my point is this: the safety needs are extremely real. They are pressing. The rights of the states to protect their citizenry, I think, is extremely well-founded and well-developed, by the way. I mean, they are seeking the right relief in the right courts. And I just hope that the Department of Justice will do as you were saying a moment ago. I hope the Department of Justice will work with these states and will also vindicate the rights of voters to decide these issues and the rights of states to protect their citizens. I just can't imagine why the department would want to defend the abortion regulations of Joe Biden, who was the most rabidly pro-abortion president in American history. Very different than our current president, who has been the most pro-life president in American history.
Senator, I appreciate the question. As in the wake of Dobbs, I agree. The law is quite clear, and I'm going to sound like a broken record, but the President of the United States has said time and again he will follow the orders that come down from the Supreme Court.
Let me ask you here about one other religious liberty issue. Are you familiar with Mark Houck? Does that name ring a bell? Do you know about this case, Mr. Woodward?
I'm sorry, Senator, I'm not familiar.
Well, that's all right. I think we've got a picture of Mark. Mark Houck is a pro-life demonstrator, peaceful demonstrator, a Pennsylvania man. Here he is with his family, his kids. They're at Mass there. He's a faithful Catholic. Mark Houck took one of his boys, pictured here, to an abortion center to go and walk on the streets, pray, and offer any counsel to any women who might voluntarily want to receive it, pray with them, etc. For this, he was arrested by the United States Department of Justice. They sent a SWAT team to his home in the early hours of the morning in rural Pennsylvania. They detained his children. They used the full SWAT regalia, including semi-automatic weapons, rifles, and so forth, to take him into custody. He was taken into custody. He was charged like a criminal under the FACE Act. He was acquitted by the jury, which is truly remarkable. I want to emphasize the state of Pennsylvania had the opportunity to charge Houck. They didn't do it because they didn't think, liberals in Pennsylvania didn't charge him because they knew there wasn't a case. The Biden DOJ charged him anyway, treated him like a terrorist, and a jury acquitted him, thank the Lord. Now, Mr. Houck is suing the Department of Justice for what they did under the Biden administration. So far, DOJ is opposing his suit. Doesn't this seem like something to you that should be settled? I mean, shouldn't this man have his name cleared? I want to emphasize the jury acquitted him, but shouldn't this man have his name cleared and have DOJ admit that what the Biden administration did to him was just dead wrong?
Senator, in my practice over the last 4 years, I saw firsthand how the Biden administration weaponized the Department of Justice, and there is no place for weaponization at the Department of Justice. I can assure you that we will look at every single case, to ensure that there is no weaponization at the Department of Justice. I look forward, if confirmed, to working with Deputy Attorney General Todd Blanche, to Attorney General Pam Bondi. We will find those cases and we will resolve them.
Good. I'm glad to hear that. I think Mr. Houck deserves to have his name cleared. I think he deserves more than an apology for what Joe Biden did to him. He deserves recompense, he deserves restitution, and he deserves to get what you have gotten for your clients, which is an acknowledgement that what the government did to them is wrong. What the government did to him is wrong. It was flat out religious persecution, nothing but that. Joe Biden trying to send a signal to every religious believer and every pro-life believer in this country, don't you dare exercise your beliefs in public, or we might come with a SWAT team and haul you off to prison. It is a disgusting abuse of the First Amendment. Thank goodness a jury acquitted him. Now he deserves to be made whole, and I hope that you'll be part of that. I see nobody else here. Are we going to let it go? Well, they tell me that Senator Cruz is on his way, which means that I can just keep right on questioning. So what do you think, Mr. Woodward? I'm sure you're really enjoying this line of questioning. Let me ask you something different. Let me ask you about President Trump's executive order on Title IX in men and women's sports. Something you and I talked about is the need to see that the president's executive orders are enforced, that states are complying with them, that they're complying with federal law. Talk to us about the importance of his order protecting women, getting biological men out of women's sports. What does the department need to do there? What do you think is the priority? And tell us why this is so significant.
Thank you for the question, Senator. You know, this is a deeply personal issue to me. I have a 2-year-old daughter who has 3 older brothers. She can hold her own, but it's a problem. It's an issue that has to be addressed. The president has taken this head on as an important issue in his administration. The executive orders speak for themselves. And although I can't comment on pending litigation that has been brought by the Department of Justice, we have seen that the Department of Justice is enforcing the president's executive orders. To quote the president, "We'll see you in court." Don't follow the president's executive order, we'll see you in court.
And you would send that message to universities that are currently failing to comply, that are violating Title IX. I mean, to be clear, Title IX protects women's sports. Title IX creates the right of women to play in sports that have integrity, where they are protected from danger, where they are given the same opportunities as male athletes. These universities that are putting biological men into women's sports and women's locker rooms are flagrantly violating Title IX. So your message to those universities is, if you don't amend your ways, you can expect to face off against the Justice Department in a court of law.
Senator, absolutely. I mean, it's a complicated issue. It's often attempted to make this out as an easy issue, but it is a complicated issue. There are sports for which it is advantageous, right? Men should not be competing in women's gymnastics, for example. And so this is not an issue that is easy to summarize or to make sound bites over. It is complicated, which is why it is important that the Department of Justice is paying careful attention to what the law is and applying the facts to the law.
Mr. Gaiser, let me just ask you about nationwide injunctions for a moment, and about the proliferation of nationwide injunctions. We have seen them explode. They're first used in the 1960s, then they're almost never used. Of course, the nationwide injunctions, when you have one individual district court that purports to bind not just the parties before the court, but purports to impose its policy, its ruling, its order on the entire country, including parties not before the court at all, parties well outside the court's geographic jurisdiction or otherwise. Tell us about the importance of reining in the district courts to their proper constitutional role, which does not allow any individual district court to sit in the place of the Supreme Court and make policy for the nation. Tell us about the importance of this.
Well, thank you very much, Senator Hawley. And as you're aware, district courts are charged with adjudicating cases and controversies. And the Supreme Court of the United States has said that that task looks to the relief sought by the parties, and its equitable authority extends to the amount of relief necessary to redress those particular injuries. And as you are also aware, the Supreme Court is currently now considering some litigation involving that, so it would be inappropriate for me to comment on the specifics of that. But I agree with you that Article 3 imposes genuine limits and authorities for district courts, and it's in the text on the judicial power.
Setting aside the litigation currently before the Supreme Court, do you think that it is appropriate and maybe necessary for Congress to use our Article 1 authority to make clear that an individual district court does not have the constitutional authority to bind parties that are not before it or otherwise not within its jurisdiction? I mean, is that something that we Congress ought to consider doing?
Senator, I agree that Congress has an important role in setting the jurisdiction of the inferior courts that Congress creates. Those are the creature of this and the House's work. And so I think this body has an important role to play and could make a significant contribution to justice being done, as opposed to what I think millions of Americans are alarmed to see, which is the weaponization of the entire justice system to oppose the agenda that they enacted by voting for elected representatives like President Trump.
Well, I think we are looking at something that is very much a constitutional crisis, that is a growing crisis, and it is a crisis of district court judges that are way outside the bounds of the Constitution, that are seizing power that absolutely does not belong to them. And you're right, Article 1 does give us the authority to establish those courts in the first instance, to govern those courts. And in this case, I think it's time for this body to take action to ensure that those courts stay within their proper constitutional bounds. Senator Cruz, I could go on for another 15 minutes, but if you'd like to ask questions, I'm happy to recognize you. They're really enjoying my lengthy questions. They've been praying you would arrive. The chair recognizes Senator Cruz.
I appreciate the always loquacious senator from Missouri, and I hope you did not have to resort to your own personal poetry to fill the time.
That was going to be next.
Well, then I apologize for depriving you of that particular joy. Let me start by welcoming today's nominees, Mr. Squires, Mr. Edlow, Mr. Gaiser, Mr. Woodward. I am grateful that the President has nominated each of you to step into these critical roles at such a pivotal time for the Trump administration. Over the past several months, President Trump has governed with clarity, purpose, and boldness. He's issued executive orders to do what the American people demanded at the ballot box: eliminate crime in our streets, secure the southern border, and put the federal government firmly back on the side of law-abiding citizens. Under his leadership, the Department of Justice is no longer targeting political opponents. It is targeting violent criminals and criminal cartels. It's restoring order to a system that for years was being used to punish dissent and to reward lawlessness. Attorney General Pam Bondi is advancing that mission with energy and resolve. But make no mistake, the far-left resistance is organized, lawless, and aggressive. Far-left activist groups are flooding the courts in D.C., Boston, and San Francisco with lawsuits designed not to win on the law, but to block the president's agenda through judicial activism. And too many judges are going along with it. In just the last 4 months, more nationwide injunctions have been issued by lone district judges than in the entire 20th century. Let me repeat that. In 4 months, we have seen more nationwide injunctions than America had seen in the entire 20th century. That's not oversight, that's obstruction. That is activism. One plaintiff in one courtroom is now able to freeze federal policy for 340 million Americans. This is not justice. It's political sabotage from the bench. And it's happening because the left can't win at the ballot box. It turns out releasing murderers, rapists, and child molesters, releasing gang members is not a popular policy with the voters. But with left-wing radical judges, that's a different story. That's why your nominations matter. The administration needs serious, principled leaders, men and women who know the law, who have the backbone to carry it out in the face of political pressure. And the American people deserve a DOJ, a USCIS, and a USPTO that defends their rights, secures their communities, and follows the Constitution, not simply the edict of activist judges. Each of you has a critical role to play in that. Mr. Woodward, you've defended clients in some of the most politically charged cases in the country. If confirmed, how will you ensure that the DOJ's civil division resists political pressure, not just from the outside, but from within, and returns to equal enforcement of the law?
Senator, thank you for the question. Thank you also for the opportunity to meet in advance of this hearing. It's an important question, and I don't want my answer to be taken lightly, but I'm not at all intimidated by political pressure. As I have demonstrated through my career, people have taken issue with lots of the work that I have done. And for me, what's important is ensuring that the law is upheld, that the Constitution is respected. And I can assure you, Senator, that if confirmed, I will make sure that the Department of Justice does just that we root out the weaponization that has been so long embedded therein. We will find it, we will eliminate it, it will cease to exist.
You've seen firsthand how prosecutions can be weaponized. What safeguards do you intend to implement to prevent civil enforcement from becoming a political tool?
Senator, I appreciate that question. As counselor to the Attorney General, I'm already working with the Attorney General to build those safeguards in. There are hundreds and hundreds of cases that are litigated by the Department of Justice. We need to know what they are. We need to identify them. We need to be prepared to understand what the arguments are. I will work very closely with the deputies that have been confirmed by the Senate and that are acting in that capacity. We will find those cases. We will organize. One of the reasons I would be so blessed to come to the department is to help organize that litigation. It's something that I've done in the past at my law firm and at the law firm that I worked before that. I'm confident that I can do it if you give me the chance.
The Associate Attorney General oversees the civil division, civil rights, antitrust, and other major components. What is your top priority for restoring public trust in those divisions?
Senator, again, I hope I'm not making light of the question because the answer is easy. Follow the law.
Mr. Gaiser, you clerked for three of the most respected constitutionalists in the federal judiciary: Judge Edith Jones, Judge Naomi Rao, and Justice Samuel Alito. All three are friends of mine. All three I respect deeply. How did those experiences shape your legal philosophy, particularly regarding the role of the executive branch in faithfully executing the law?
Well, thank you so much for that question, Senator Cruz. When you're a law clerk, your first task is to do your best to state the law in a way that the judge can use your work. And you're not the decider. You're there to do research, to provide your independent, candid, and honest view of the law. And should I be so fortunate to be confirmed as the Assistant Attorney General of the Office of Legal Counsel, that would be my primary aim, to always provide the best reading of the law and the best legal advice that I could give based on the questions that the Office of Legal Counsel receives.
Thank you. And Mr. Squires, the PTAB was created to improve patent quality and to provide a faster, cost-effective alternative to litigation. But in recent years, many small inventors and startups have expressed concern that it disproportionately favors large challengers and undermines the value of their patents, that is effectively an arm of big tech. What is your assessment of those concerns, and do you believe the system is functioning as Congress intended?
Thank you for the question, Senator. I think if you look at the data, the concerns are in plain sight. The IPRs themselves have a 68% defect rate, if you will. If the American patent system is a factory, 68% of the products we put out are found defective in a later proceeding. So the way to address it is to have patents, if I can harken back to my opening statement, born strong. We need to be able to incentivize getting the prior art in at the examination stage or closely thereafter, and having the improved quality, I think, will alleviate many concerns. There's also concern I have with IPRs that if, in fact, there is this prior art out there and validating patents at these great rates, is it or is it not getting back into the system in the examination on the front end so it can be applied when the applicants are asking for rights?
Okay, and a final question to Mr. Gaiser and Mr. Woodward. I talked about the avalanche of nationwide injunctions we're seeing from individual district judges. How concerned are you about these nationwide injunctions, and what can be done to ensure that judges stay in their proper lane rather than trying to subvert the authority of the president and the will of the people who elected him? Mr. Gaiser, we'll start with you.
Well, thank you, Senator Cruz. As Solicitor General of Ohio, I have the privilege of defending Ohio's laws against statewide injunctions that are sometimes sought. And I always make the same argument that courts are empowered to offer relief no broader than necessary or burdensome than necessary to redress the injury of those who are properly parties before the court. I think courts should follow that guidance, which the U.S. Supreme Court has long established and dates back all the way to the Anglo-American legal tradition in equity.
Mr. Woodward.
Senator, I am very, very concerned. It should not be the case that a president duly elected then has to convince 600 individual judges to enforce the policy prerogatives of that administration. This is a bipartisan problem. This is a problem that has persisted, as you observe, for some time now. It is a problem before the Supreme Court, and of course it is the policy of the Department of Justice not to comment on ongoing litigation. But candidly, it's a problem I'm not sure the Supreme Court will solve. You know, as I look in the Constitution, Article 3 doesn't seem to have any discussion of nationwide injunctions in it, and so it's a dubious one, to be sure. Let me be clear, however, is that it is not a problem I am unafraid to face. If confirmed, we will take on all of the litigation in these courts. We will defend the president's prerogatives, and as a criminal defense attorney, I can tell you that I'm used to losing in the district court. We make our record, and that's why God invented the Court of Appeals.
Amen. Let me thank each of the nominees. Thank you for being here today. Written questions to the nominees may be submitted for the record until May 28th at 5 p.m. And with that,